Salutations, respected viewers. This is part of my very brief précis of English law, an introduction to English law. And now I'm going to look at European law. But you might say, what? You said English law, not European law. Well, in 1973, the United Kingdom acceded to the European Economic Community, which has subsequently turned into the European Union. Now, since 1973, some European law has come into English law. Even prior to 1973, there was always a dialogue between the two systems. They were never totally distinct. And English law, in its earliest foundation, going back to the 10th century earlier, did draw upon some Roman law traditions. Anyway, the United Kingdom is still a member of the European Union for the moment, although it might actually turn out to be staying for the long term. We shall see. So most European Union countries follow Roman law. Roman law is sometimes called civil law, like Justinian, the Byzantine emperor. He wrote that corpus, what is it called, Juris Civilis or something like that. The Byzantine Empire, based at Istanbul, Eastern Europe, a bit of the Middle East, but they were Romans. Romeoi, they'd call themselves, Romans. And that's one of the earliest digests we have of Roman law. So Roman law is sometimes called civil law as opposed to common law, confusingly. And then within common law, i.e. English, we also have civil law to mean non-criminal. I know. The way that these words have multiple meanings discombobulates many people. But anyway, we'll just say Roman law here for ease. So, the United Kingdom has absorbed some Roman law. There are some common law countries in the EU besides the United Kingdom, Republic of Ireland, Malta and Cyprus. Even within the UK, there is one country, if I can say country, which is mainly a Roman law country, and that would be Scotland. So Roman law is more about consistency and predictability rather than doing justice on the basis of the individual circumstances of each case. And there's obviously something to be said for both approaches. Why did a court make such a decision in this case? It's an analogous case, and they made a different decision. This is an anomaly, and that's the kind of thing that can happen in English law. Whereas Roman law, they say, no, we must keep it the same, and that is justice, is consistency. How come you made, this decision in that case, another decision in a similar case? English law, that's wrong. No, same decision in the same case. Now, the English law approach would be, no, but one must take into account the particularities of each case. So the European Economic Community was founded by the Treaty of Rome in 1957 and initially had 6 member states. The Benelux countries, Belgium, the Netherlands and Luxembourg, France, Italy and West Germany. Doesn't exist anymore, the Federal Republic of Germany, but Germany is a divided country, 1945 to 1990. Won't go into that. So the EEC was about trade, mainly regulating trade. There was a precursor organisation to it, the European Coal and Steel Community, so that France and Germany would never go to war against each other again, because coal and steel were two of the things that were vital for war industries, and they would be shared resources. And indeed, in the Benelux, Belgium, the Netherlands and Luxembourg, as mentioned, they'd had a customs union for some years, and indeed that was sort of an embryonic European Union as well. So, predating the EEC is the European Convention of Human Rights, which was drawn up in 1948, and it was drafted by lawyers from many European countries, including the United Kingdom. So, many countries participated in this, and they founded the European Court of Human Rights, which is based at Strasbourg in France. Now, this causes great confusion, because Strasbourg is one of the capitals of the European Union. The European Union's parliament, it alternates between Brussels in Belgium and Strasbourg in France. Whereas the European Court of Justice is in Luxembourg. So in a sense, the European Union's got 3 capitals. Mainly it's Brussels and Strasbourg. So the European Court of Human Rights is not a European Union court. It's a very common misconception. Anyway, all EU member states must be signatories to the European Convention of Human Rights. However, many countries are signatories to the European Convention of Human Rights which are not members of the European Union. There are 28 member states of the European Union at the moment, and there are other countries, up to another 20, who are also signatories of this, but are not members of the European Union. So each country that is a signatory of the European Convention of Human Rights sends a judge to Strasbourg and the European Court of Human Rights, and the court will hand down judgments. However, these can't actually be enforced. It's up to governments to go along with them or not. Now, there have been a number of rulings against the United Kingdom by the European Court of Human Rights down the decades. And the United Kingdom was not legally obliged to actually give effect to the ruling of the court, but always did so. For example, when some terrorists were shot dead in Gibraltar in 1988, there was a case about that. Several years later, the European Court of Human Rights decided that these people had been deprived of their right to life. They'd been shot dead. It was claimed that there was not a proper chance for them to surrender. That was that. The UK was ordered to pay a lot of compensation. The UK did so. There was a lot of grumbling, said, oh, this is a completely unjust ruling. But anyway, the UK did it. So the European Union considers the European Convention of Human Rights the core of its legal tradition. And now there's the European Court of Justice, which I mentioned, based in Luxembourg. And the European Court of Justice openly says that it looks to the European Courts of Rights and it learns from its jurisprudence. So although these two courts don't regard them as rivals or competitors, they're allies in a sense. There's a dialogue between them. So all EU member states are required to have the European Convention of Human Rights as part of their domestic law. That was part of the Treaty of Amsterdam in 1997. In 1998, the United Kingdom passed the Human Rights Act, which domesticated the European Convention of Human Rights, brought it within the UK's own law, and it only kicked in 2000. Now, it's possible to get derogations from that. For instance, to say this is an emergency situation, therefore we can intern people. And briefly after 9/11, the UK did invoke that and locked some people up for several months without charge. But that's all over since. So the European Convention of Human Rights, well, much of it is uncontroversial. You will have found many of its provisions in English law for decades or even centuries prior to the compiling of the European Convention of Human Rights. And much of it is lifted almost verbatim from Magna Carta. That's the 1215 document issued by King John when he was trying to placate the barons during their baronial rebellion. So that's that. And the European Court of Justice is to regulate the relations between the different European Union institutions, between the European Parliament and the Council of Ministers and so on, between different European member states and so forth. It's not really about criminal law. So the European Convention of Rights guarantees all sorts of things, family life and so forth. Now this comes to one of the key distinctions between English law and Roman law. There's English law believes in permissive liberty. People are allowed to do anything unless that is specifically prohibited, whereas Roman law appears to start from the opposite assumption, that things are not allowed unless they're specifically permitted, as in the right to family life. You might say, well, I don't need to be told I have the right to family life. Of course I have the right to family life. I'm entitled to do anything unless it's actually forbidden. And it goes on like that. There's the right to life, as in the death penalty is forbidden. It does provide how it could be brought back in under extraordinary circumstances. No EU member state seems to have come even close to doing that. But obviously it says that the state is entitled to use force if they are fighting or quelling a riot, things like that. Things like servitude are forbidden. However, it says that sometimes compulsory military service or other compulsory social service could be permitted. If there was a flood and we needed everybody to start building up flood defences, then we could oblige people to do that for one day or something like that. That would be an example of what would be permitted. And it goes on, freedom of expression, but it has to balance that with the right for someone not to have their reputation trashed. So that's what the European Convention of Human Rights is about. So 1973, EEC, as I mentioned, well, the United Kingdom, Republic of Ireland, we joined in that year. And it was about trade between these countries, reducing regulations, harmonising regulations, and sometimes squabbles about what was allowed, what wasn't allowed, generally speaking about the four freedoms, the freedom of movement for capital, people, goods and services. Mutual recognition of qualifications. Someone who's a dentist in Belgium, he or she is also a dentist in Croatia. He or she can also practice dentistry in Portugal or Finland or wherever it may be. And if you're providing mobile phone services in Luxembourg, your mobile phone services must also be available for people in Latvia or the Republic of Ireland or wherever, things like that. So this is what it's about. And there was the Merchant Shipping Act in the 1980s, the United Kingdom, about who was allowed to have fishing fleets and so on. And it led to a very famous case called Factor Tame, which lasted for years. And it proved that Parliament has to follow European directives. So the European Union governs through three ways. Let's say regulations, which apply to everybody in the European Union. Directives, which are to the member states, saying the member states must do something by a certain deadline, and they have to transpose that into their national law. There'll be a minimum standard they need to reach. They could go further than that standard, saying you must have these working hours, a certain safety standards, and then national parliaments legislate on that basis. And the UK Parliament has always legislated on that basis. People often don't realise just how much legislation passed by Westminster is on the basis of giving effect to EU directives. And last of all, their decisions, which apply to whoever whom they are addressed. Could be to one member state or whatever group of people, and so on. So that's the way the European law works. The rest of it is more political about the debate between intergovernmentalism, supranationalism, how much power the member states should have, qualified majority voting, things like that. It gets very technical about whatever quantitative restrictions and things like that. The extent to which member states are allowed to forbid certain items on moral grounds, if you think something is immoral, things like that, or to prevent the export of certain items which are very important to your national patrimony. So it could go on all day. But that is just very scratching the surface of a few of the core principles of EU law.